I've seen this with almost all big companies. They have most of their IP filed by a big law firm or two, but we'll have some smaller number of patents, usually filed by a couple of small law firms. Okay, someone's very perceptive. I didn't actually know that. Is there a reason for that? And are they good law firms to work with? Thanks in advance.
Never confuse the cost of something with its value.
Ah, there it is. Beautiful.
Yep, just dropping knowledge right there.
I mean, I think also what can happen with big law firms, as opposed to smaller law firms like Bolt, is they have nasty conflicts, really big mammoth conflicts. True. They have big clients, True. Facebooks, Amazons, maybe even not even necessarily that big, but the big set. And they can say you're not allowed to have any other clients in.
Yeah, if you have one of those big clients, you potentially conflict out of all their vendors potentially too.
Huge, yeah, huge. And so that could be a reason, why they've got maybe this subset where they think, this could be conflict. Not even it is, but it could be eventually become a conflict. Or hey, we just actually want to make sure we're getting good service from these big law firms. Sure. Let's go see what we get from these boutiques, so we can match up and keep the big law firms on their toes.
Yep.
And so you see that a lot with all sorts of things. If you have one employee doing the role, you're not really sure if they're doing a great job because no one to compare them against. So comparison's always good. I don't know. Do you have any other ideas why they might kind of diversify?
Yeah, no, I think the conflict one is a really, really good example. Conflicts at the big firms are really prevalent, right? I can't remember the amount of times that I've sent off some, larger trademark litigation work to a mentor of mine at one of the big firms here in Minneapolis, and he's had to decline it because he has represented, an adverse party or someone that his firm has, right? So and that's why the big firms, they hang out with the big corporations because they have to. There's no one else they can work with really sometimes.
Totally.
The only thing that go ahead. Oh, the only thing I was going to say is that also I don't know the file history, obviously, of all these patents or trademarks or whatever, but it's entirely possible too that these trademarks and patents were filed by smaller entities that eventually formed a partnership or became part of the larger company, and they've kind of kept their existing counsel, on those matters. I know I have a few clients like that too that I do trademark work for who've since blown up and become huge and have moved on to larger firms, right? But we still handle the few trademarks that we file for them to begin with.
Right. Yeah, there's a certain amount of loyalty, to.
Yeah, I think so. And just inside baseball here, the pitch from a lot of large law firms is like, hey, like you're doing business law with me, like we got this trademark patent practice, like I'd like to take everything in house just to keep the things really clean and billing easy, and I can communicate with JD over here a lot easier because he's next door to me.
Right.
It's not really reality, but.
Right. Yeah. Well, I think that is the idea, sort of, save on the administrative costs, save on, having multiple attorneys. Sure. But you've got to weigh the benefit of that versus are you getting the quality service? Are you getting the kind of representation you want?
Sure. And I will say, I've gone up against large corporate opposing counsel many, many times over the last 14 years. Yeah. By and large, they're very good at what they do. Big law is not hiring dummies typically. So,
no. Not at all. No.
And they got lots of time because they bill by the hour. So they don't mind dragging stuff out and making life hard. So
yeah.
Whereas our clients are typically they want the best outcome for the most reasonable amount of money possible, right? So
totally. Yeah. I was going to say earlier. I think legal ethics and conflicts is a huge topic, and I think we can spend a bunch of time, on that.
Annoying but important.
Yes. And the things we think about, what we look at are two main types of conflicts: so procedural or substantive. So procedural is where you've got, hey, I know this person, I'm not going to be able to be impartial, or there's opposing side of a dispute with just the name. And then certainly for patents, and I think maybe for trademarks too, substantive conflicts where, hey, we're actually helping a client with the exact same invention. And it's super tricky. It's only come up, we've been in this 10 years, less than 10 times, right? Where we actually, this is so close. And in those cases, we have to walk a very fine line of not telling either party that either one of them exists. They're on their own. And we're just sort of the gatekeepers of that. And the cool thing about representing smaller inventors is it is usually limited in scope, right? And so we can represent multiple inventors, let's say in athletic shoes, right? If the claim of that is all about the air properties within the chamber of the article of shoe, and the other one is about the way the laces lace up, that's completely different in terms of what functional out. So a lot of little discrete things versus having large portfolios from larger clients.
It's relatively easy for me on the trademark side when it comes to conflicts because, one, if I recognize the brand or, have the association like, oh, this sounds a lot like this other client's brand, right, in the same industry, right, that's going to be a conflict. I've never had that happen. But one of the rules I was taught in law school a long time ago was, if you're doing a search report for a client and you find in that search report another trademark that you've applied for on behalf of another client, that's a conflict. Right? Because you can't be expected to be, fair and impartial when you're doing analysis about your own trademark work.
I like it a lot. Yeah.
But honestly, like I think of the 1,500 trademarks that I've filed, I think I can only think of 2 conflicts. In that whole time, it just doesn't happen. There's so many trademarks that are filed, and it's rare for me at least.
Totally.